So Andy, let me follow up with that and ask, kind of maybe pull out your crystal ball. We only have 3 opinions from 3 state bars, and we all know here, I think, as a panel, how the state bars lag behind technology greatly in coming to conclusions about new types of technology. Does that mean, the fact that we only have 3 opinions, does that mean that we're done? That's it, and the other bars are just going to kind of follow along and silence equals acceptance here? Or what do you expect to see in the next couple of years in terms of how the bars are going to treat software as a service?
Well, from experience in teaching law students, which I taught law practice management for 8 years, we're starting to see a whole different crop of law students coming out of school, not just how to use computer, but dealing with the laws that regulate how you use computers in the practice. And I think what we're going to be seeing is that the push is going to keep, you're going to see this mound that's going to keep pushing technology, and technology is going to push the law. So I see in 5 to 10 years, I think this is going to be a moot point. We'll be having a different conversation, because I think that everyone will have decided that the technology is there, the security and reliability is there. Now it's the matter of dealing with the culture of the firm, the individuals within the firm, and how comfortable they are in moving to that technology.
I just wanted to add there, though, I think that part of this also is it's really a matter out of the bar's hands. It's one thing for bar associations to want to protect client confidentiality. For example, if I am defending a criminal client and I put on the internet that he really, memo to self, he really did it. Lawyers are now also gaining access to information, social security numbers, bank account numbers, information that is vulnerable to theft and the possibility of identity theft. And we're seeing a lot of laws that are being passed, state and federal laws relating to data breach, relating to what people can do when they get that kind of information. I think that eventually it's inevitable that, at least to the extent that lawyers are handling that kind of information, that's something that's got to be regulated by law. Whether a bar tells me to be careful or not, I've got to do what a statute says. I mean, we see with doctors, healthcare information is regulated by HIPAA, and I think that with a lot of these, at least to the extent that lawyers are taking information that relates to personal identity, this is all going to be regulated by state and federal law. It's really something that's beyond the bar's control. I think what the bars can do is come up with best practices or help lawyers to comply with the statutes, just the way that the AMA helps doctors to comply with HIPAA. But in terms of setting the standards, I think this is something that's going to have to be done by statute, because a lot of that information to begin with is created by state law, driver's licenses, social security numbers, and so the protection has got to come from statute, I think.